Good evening. Union Home Minister Amit Shah today launched a frontal attack on the Congress and the opposition, saying standards of morality cannot be linked to victory and defeat in elections. He mounted a strong defense for the 130th Constitution Amendment Bill that talks about removing any minister, whether in the centre or the state, any chief minister or even the Prime Minister, if they're in jail for more than 30 days in a serious case, including corruption, and with a sentence of 5 years or more.
Home Minister Shah tears into opposition on graft.
बहुत स्पष्ट मानना है, मेरी पार्टी का मानना है, देश के प्रधानमंत्री का मानना है कि इस देश में कोई भी मुख्यमंत्री हो, मंत्री हो या प्रधानमंत्री हो, जेल में रहकर सरकार नहीं चला सकती।
Reminds Rahul of his anti-graft raga.
मनमोहन सरकार एक ऑर्डिनेंस लेकर आई कि 2 साल की सजा हो तो भी अपील का स्टेज बाकी है। यही श्री राहुल गांधी इसको कंप्लीट नॉनसेंस कहकर सार्वजनिक रूप से प्रेस कॉन्फ्रेंस में फाड़े थे।
Shah slams political doublespeak.
मोरालिटी के स्टैंडर्ड्स चुनाव के जय पराजय के साथ जुड़े नहीं है। मोरालिटी के स्टैंडर्ड्स सूर्य और चंद्र की तरह हमेशा अपनी जगह पे स्थिर रहने।
Opposition mocks Home Minister's morality message.
Speaking about morality is the greatest joke in this century. Mr. Amit Shah is speaking about morality.
Criminal Neta's Bill's Showdown. That is our top focus on India First.
The 130th Constitution Amendment Bill has been referred to a JPC or a Joint Parliamentary Committee. This has 31 members, 21 from Lok Sabha and 10 from Rajya Sabha. Amit Shah insists a democratically elected government has the right to table any bill, including a Constitution Amendment Bill, and any points if the opposition has. They should make it in the JPC or during debate. Anyway, it requires 2/3 majority to be passed to become a law. If the government has numbers, it will pass. But why is the opposition, according to the minister, shying away from a debate? And the question we're asking is the opposition shying away from a debate on the Constitution Amendment Bill? Is the bill an attempt to bring constitutional morality in public life? Or, as the opposition puts it, is it against the principles of natural justice? Manish Tewari is Member of Parliament from Chandigarh, former Information and Broadcasting Minister in the UPA government and a lawyer by profession, joins me on India First. We'll tell you all about this bill and all sides of the debate. I'm Gaurav Sawant. As always, let's get started with the headlines on India First. Prime Minister Narendra Modi on a 2-day trip to Gujarat emphasizes that small entrepreneurs, farmers, cattle rearers are his government's top priority. Assures the nation no harm will come to them, no matter the pressure, a way will be found.
मेरी सरकार लघु उद्यमियों का, किसानों का, पशुपालकों का कभी भी अहित नहीं होने देंगी।
A Noida woman is burnt alive in front of her child for dowry. Sources say her husband objected to her Instagram reels. Nikki's father breaks down, demands death penalty. All 4 accused, including husband Vipin Bhati, arrested. Big revelation in the Delhi Chief Minister attack case. Police alleges Rajesh and his friend Tehseen plotted the knife attack on the Chief Minister. The attacker threw his knife after seeing high security at a residence. His friend Tehseen has also now been arrested. TNC leader arrested by the Enforcement Directorate in the teacher recruitment scam for not cooperating with the probe. Jiban Krishna Saha threw his phone in a pond during the raid. He tried to escape. He jumped from the first floor of his house, scaled the roof, but the ED was waiting. India's space hero, Group Captain Shubhanshu Shukla, gets a hero's welcome in Lucknow. Meets Uttar Pradesh Chief Minister Yogi Adityanath, who announces the state will launch a scholarship in Shubhanshu Shukla's name. Can a government be run from prison? Union Home Minister Amit Shah today strongly defended the 130th Constitution Amendment Bill, insisting constitutional morality and public trust have to be upheld. No Chief Minister, no minister, whether in the center or in the state, or even the Prime Minister in this country can run a government if they're in jail for 30 days or more. He hit out at what he called was Rahul Gandhi's double standards. He tore the ordinance in 2013 that protected those convicted of crimes with the punishment of 2 years or more. And today, the Congress is opposing the 130th Amendment Bill. The opposition came out all guns blazing, targeting the Home Minister's defense of the bill. Our political bureau gets you our top story.
After mega showdown in Parliament, the political battle over anti-criminal Neta Bill has escalated sharply. Union Home Minister Amit Shah defended the proposed law that seeks to oust Prime Minister, Chief Ministers and Ministers held in custody for 30 consecutive days on serious criminal charges. Shah, in a hard-hitting counter, argued that the country cannot be run from jails, taking a direct swipe at opposition parties for what he called political doublespeak.
मैं से देश की जनता को और पूरे विपक्ष को भी पूछना चाहता हूं, क्या कोई मुख्यमंत्री, कोई प्रधानमंत्री या कोई मंत्री जेल में रहकर सरकार चला सकता है क्या? और अगर 30 दिन के बाद जमानत मिल जाती है तो वो फिर से शपथ ले सकते हैं। हम मल्टी पार्टी पार्लियामेंट्री डेमोक्रेटिक सिस्टम में है। जब आपके पास सदन में बहुमत होता है, एक मुख्यमंत्री को किसी भी कारणसर जेल में जाना पड़ा, 30 दिन तक जमानत नहीं हुई, तो अब वो पदमुक्त हो जाएंगे, परंतु उनका बहुमत तो बना रहेगा। किसी भी सरकार के विधेयक को या संविधान संशोधन को सदन में पेश न होने देना और इस तरह का व्यवहार करना, ये क्या लोकतंत्र में उचित है क्या? मुद्दे का विरोध हमने भी देखा है, हमने भी करा है, परंतु बिल को पेश न होने देने की एक प्रकार की ये मानसिकता, मैं नहीं मानता हूं कि ये लोकतांत्रिक है और विपक्ष को देश की जनता के सामने इसका जवाब देना पड़ेगा।
Amit Shah pointed out that the bill even includes the Prime Minister's office and reportedly at Prime Minister Modi's insistence.
पहले 39वां जो संशोधन था, इसमें इंदिरा जी उपराष्ट्रपति, राष्ट्रपति के साथ साथ खुद को भी इनके खिलाफ कोई वैधता नहीं रहती है चुनावी मुकदमों का एक संविधान संशोधन लेकर आई थी। वो खैर कांग्रेस पार्टी और श्रीमती इंदिरा गांधी की नैतिकता का सवाल है। नरेंद्र मोदी जी अपने खिलाफ खुद संविधान संशोधन लेकर आए हैं कि प्रधानमंत्री भी जेल में जाएगा तो उसको इस्तीफा दे देना पड़ेगा।
Home Minister Shah cited his own example and said that he had himself quit after facing charges and did not return to cabinet before being cleared by the court. Shah also hit out at Rahul Gandhi's shifting stance on morality, recalling how he once publicly tore up an ordinance protecting convicted lawmakers like Lalu Prasad Yadav.
और मैं आज जो कांग्रेस पार्टी इसका मुखर कर विरोध कर रही है, वो कांग्रेस पार्टी के एक स्टैंड को ही मैं कह रहा हूं। जब यूपीए की सरकार थी, श्री मनमोहन सिंह जी इनके प्रधानमंत्री थे और लालू प्रसाद यादव जी इनके मिनिस्टर थे। लालू प्रसाद जी को सजा हो गई। मनमोहन सरकार एक ऑर्डिनेंस लेकर आई कि 2 साल की सजा हो तो भी अपील का स्टेज बाकी है तो उनकी सदस्यता नहीं जाती है।
Amit Shah expressed confidence of getting the bill passed in Parliament and said that many opposition leaders will support the bill on moral grounds. But opposition parties are not buying it. Arvind Kejriwal, who spent 160 days in Tihar jail in liquor scam case and still served as Delhi Chief Minister, hit back at Amit Shah. defending running his government from jail and calling the charges a political conspiracy. Opposition called Shah's talk of morality a joke.
23 जुलाई को ये इनके खिलाफ गिरफ्तारी का निकला था, ये गायब हो गए, छिप गए, भाग गए। गृह मंत्री एक राज्य का भाग गया, उस राज्य की पुलिस को नहीं मिल रहे थे अमित शाह। फिर जाके इन्होंने इस्तीफा दिया, फिर ये पकड़े गए सीबीआई द्वारा, शिकंजा इन पर जकड़ा, तब पकड़े गए ये। कोई पहले 2 दिन पहले इस्तीफा दिया, झूठ बोल रहे।
As the debate continues, the question lingers: will this amendment safeguard governance or become a tool for political vendettas? Bureau Report, India Today.
Let's dive straight into this debate. Joining me on India First is Manish Tewari, Member of Parliament from Chandigarh, former Union Minister, Information and Broadcasting, former Member of Parliament from Ludhiana and Anandpur Sahib. You're a lawyer yourself, a lawyer par excellence who's authored 4 books. Sir, welcome on India First.
Thank you very much, Gaurav. Thank you for inviting me.
Sir, you're not only a multi-term MP, you're a leading lawyer. You understand the constitutional jurisprudence very well. You've called this bill squarely destructive. Why so, sir, when the Union Home Minister asks, should anyone run the government from jail, either get bail within 30 days or take over whenever you get bail? Governments cannot be run from prison.
Gaurav, that's a very malicious way of even framing the debate for the Home Minister. And allow me to explain and contextualize why. Going back to the times of the ancient Greeks and the ancient Romans, when the fundamental postulates of common law started evolving, there is one grundnorm or basic postulate. That is, you are innocent until proven guilty. These constitutional amendments, or this constitutional amendment and consequential amendments in the Union Territories Act and the Jammu and Kashmir Organization Act, stands that fundamental maxim on its head. Essentially, it holds you to be guilty without even as much as charges being framed against you. That is number one. Number two, Article 21 of the Constitution of India guarantees that you will not be deprived of your life and liberty except in accordance with the procedure laid down by law. This is the due process clause. So therefore, under those circumstances, the registration of an FIR, an arrest, if required, investigation, filing of a charge sheet, and even framing of charges is absolutely no evidence of any culpability or guilt. In fact, you only plead not guilty once charges are framed against you.
Yes.
That's when the trial formally commences. So what this constitutional amendment is doing is standing the fundamental jurisprudence of Article 21 on its head. Number three, there is a collective responsibility which the cabinet has to the legislature. So therefore, under those circumstances, the constitutional scheme as it is structured does not contemplate that the collective responsibility of the Council of Ministers lies to anybody except the legislature. In this particular case, the whole concept of collective responsibility, has been turned on its head.
Okay.
And then all constitutional safeguards with regard to due process, with regard to disqualification are only after conviction, and that too by the highest court of the land. Everything has been upturned. And you cannot enforce morality by law. And that is the experience of the 10th schedule or the so-called anti-defection law, or the amendments which were carried out with regard to open voting for the Council of States.
But sir, shouldn't morality in public life be supreme? Point one, point two, and all the objections that anyone may have, and especially our honorable lawmakers, shouldn't they be debated in Parliament and in the JPC? The Home Ministers argued that elected government in Parliament can bring any bill. They can bring constitutional amendment. What objection can the opposition have in a bill being tabled on the floor of the House? Why tear it into pieces or words to that effect? And I want to ask you, sir, he says, discuss it in JPC, put it to vote, express your opinion. It's a constitutional amendment, 2/3 majority would be required. Why is the opposition not keen to go through that entire parliamentary process?
For the simple reason, beyond the 7th schedule, Article 246, the union, state, and the concurrent list, lies the basic structure doctrine of the Indian Constitution. And the basic structure doctrine holds that there would be rule of law. And rule of law, or implicit or explicit in that rule of law, or the foundation of that rule of law, is the presumption of innocence.
Yes.
Until proven guilty in a court of law. The government cannot bring legislation which hits at the basic structure of the Constitution. Number two, democracy has been held to be a basic structure of the Constitution. And here you are actually throwing the rights of the elected representatives completely to the winds by making an investigating officer the boss of the Prime Minister of India. Try and countenance the implications of what this is. Suppose I am the Chief Minister of an A state,
Yes.
hypothetically speaking, and I travel to B state, and I am arrested there. I am put behind bars for 30 days. Bail is not granted. My chief ministership is gone. And let me extrapolate even further. God forbid, if you have a situation where you have a mischievous chief minister and he does the same to a prime minister. So try and imagine the implications of what you have really brought. Today you have two chief ministers of Punjab and Haryana who live in the union territory of Chandigarh, which is controlled by the central government.
Yes.
Once this constitutional amendment comes into force, which I hope it doesn't do, because it is completely egregious and unconstitutional, you will find both of them will not live in Chandigarh. One will go and live in Mohali and the other one will go and live in Panchkula.
Okay. But
So therefore, the weaponization of our law enforcement instrumentalities, both at the center and the states, is a reality, right? It is not as if you are living in a completely utopian system whereby everybody is acting in accordance with law.
But sir, a police officer, even if he were to arrest somebody, there are courts of law at every level. A trial court, a superior court, high court, division bench, supreme court. There are so many avenues of grievance redressal. And is this a debate about constitutional morality and public trust? I mean, look at, it's about the Prime Minister, the Chief Minister and the ministers. Caesar's wife should be above suspicion principle. Shouldn't that be adopted in public life if it leads to charges and arrest? Secure bail from multiple courts on law. And sir, you as a lawmaker in Parliament who understands law so well, you can bring in systems where safeguards and checks and balances can be inbuilt into this law.
I'm sorry, Gaurav, this constitutional amendment is extremely mischievous, but from purely a constitutional standpoint, anything which stands the presumption of innocence until proven guilty on its head and then triggers action based upon that is completely and absolutely unacceptable. I was giving you the example of the 10th schedule.
Yes.
You brought in the anti-defection law with all good intentions in 1985. What happened? A retail activity first became a wholesale activity, then became a supermarket, and now has become a mega mall. Have you been able to enforce constitutional morality through law with the 10th schedule? You brought in open voting in the Council of States in order to ensure that there is no cross voting or voting does not take place for extraneous considerations. Has it really stopped people who allegedly, possibly may not have the most honorable of credentials from coming into the Council of States? The answer is no. So, therefore, the simple reason is constitutional morality or morality is purely a personal choice. You cannot enforce it by the rigors of law. If I feel that I should step down, if at all I have been rightly or wrongly charged or something, that's entirely my prerogative. You cannot stand the entire judicial system of the country on its head just because you want to enforce some principle of spurious or extremely dubious morality.
Okay. And how do you see the parallel that the Home Minister tried to draw between the 39th Amendment protecting President, Vice President, Speaker, and of course the Prime Minister being brought in, into that from judicial review to the 130th Amendment bill where the Prime Minister wants to bring himself under review. No insulation even for the Prime Minister, the Home Minister said.
Well, you already have the Lokpal. That is why you created the Lokpal. You created an institution over and above the elected political executive, primarily because of such dubious reasoning. Even at that point in time, I was in a minority of one, and I strongly opposed the constitution of the Lokpal, primarily because I felt that you cannot have an overarching authority over and above the political executive when you have a complete investigative machinery and a judicial system which is independent of the executive. So therefore, I keep stressing that you cannot have a situation whereby because it suits you at a certain point in time or because you feel that these constitutional instrumentalities can be weaponized against your political opponents, you do it for short-term gain. The implications of these amendments are absolutely portentous and ominous, and they will reverberate beyond the tenure of all these governments. So essentially, when you sow the wind, you reap the whirlwind, and these constitutional amendments, and I've only outlined some of the implications of these amendments. If at some point in time I can chapter and verse narrate 10 more portentous implications of how if these amendments ever actually become law, what they would do to the political system.
So
Eventually,
on the charge,
collective responsibility of the cabinet,
yes,
whether at the central level or the state level, is not to an investigating officer. It is to the legislatures. And here you are saying, if you are arrested, absolutely on a false charge perhaps, and you are not able to get bail for 30 days, either the chief minister will sack you or you get automatically sacked. Or if you are the chief minister, if you do not resign, you will automatically go. The same applies to the union legislature.
Sir, but explain this to me. If a person arrests you wrongly, arrests a minister, chief minister or prime minister wrongly, there are multiple levels of courts of law who will go into those arrests, and if that arrest is wrong, grant bail. If not in 30 days, in 35 days, 40 days is the point the Home Minister is making. Point one.
I am sorry.
Also the point. Okay, go on, sir.
You have provided for safeguards in the Prevention of Corruption Act by inserting Section 17A, saying that without sanction, you cannot register FIRs against public servants. And here, you are turning that entire safeguard completely on its head by saying that you can be picked up at any point in time in possibly a false FIR, and if you are not able to secure bail in 30 days, off you go. And tomorrow, when that case goes to trial and your innocence is established, who is really going to account for the reputational damage?
Okay.
And over and above that, what is the dangerous precedent you are setting? The dangerous precedent you are setting is that thousands of years of jurisprudence, which says innocence is the fundamental maxim.
Okay.
You have to be proven guilty beyond reasonable doubt in a court of law.
Okay.
The moment you have a situation whereby there is an arrest and after 30 days there's a resignation, you have explicitly or implicitly turned that principle on its head.
But didn't the Honorable High Court also say exactly the same thing in reference to a Chief Minister, that he should ideally have resigned, but the High Court said so, that they believed he should resign on moral grounds, but there is no provision in the current law to make him do so. The Home Minister in this interview says that his party and the Prime Minister believe that no CM, Minister or PM can run the country while being in jail. When the Constitution was debated, the makers of the Constitution did not imagine, in his words, such shamelessness, that such a Chief Minister would continue to operate from jail as Chief Minister, and that is why this amendment is required.
Well, what about the shamelessness of all those people who triggered up investigations against people who ultimately were not even charged at the end of the entire process and had to spend 2.5, 3 years in jail? Who is going to account for their reputational damage? Unfortunately, the law of torts is not developed in this country.
Yes.
Otherwise, if these investigating agencies who act in an arbitrary and malicious manner would have been slapped with damages like it happens in the United States of America and some other jurisdictions of millions and millions of dollars, all this would stop immediately. If they would be made personally culpable, that God forbid tomorrow, your investigation is found to be tardy and the person ends up getting acquitted, you will be held responsible as to why did you initiate the process in the first place. There you have given protection for actions in good faith.
So
what is the conviction rate of your agencies?
So
what is the conviction rate of your police forces? Ultimately, the difficulty in this country is the process is the punishment. So therefore, you make the process so excruciating and full of harassment that eventually, when a person gets discharged, and if he happens to be a public person, the arrest would be splashed on the front page of every newspaper and would be headlines of television channels for days to an end.
Yes.
And the acquittal would be buried in probably a little ticker running at the bottom of your screen, or maybe on the 17th page in the 28th column of some newspaper.
So, sir, should this come up in the JPC, would the Congress, in your view, go through this process? Because there are some political parties, part of the India bloc, that are indicating they will not be a part of this process at all.
If you personally ask me, that's a call which the Congress leadership has to take. But if you personally ask me, these amendments are absolutely excessive. Because experience has shown, Gaurav, as I pointed out with the 10th schedule or the open hand voting in the Council of States, that morality cannot be imposed through a legal process. Morality is absolutely an intrinsic instinct. Either you have it or you don't. And if you try and impose it from outside, you will, it'll meet the same fate what the 10th schedule has met, whereby government after government has been toppled by dubious means, where you have presiding officers who do not decide on petitions, for years to an end, terms of the assembly end. The person goes from one party to another, comes back to his original party, but the defection petition keeps is pending.
Okay. Okay.
So under those circumstances, what really are we talking about here? Eventually, ethics and morality does not come out of legal coercion. Ethics and morality comes out of an individual's sense of whether he or she feels or thinks
Okay.
that since they are a public person, irrespective of the fact that they may have been very horribly wronged, they would like to step aside, till the process plays itself out.
Will
That's
we see
purely
that
an individual
morality
choice.
in our leadership, and especially our ministers, chief minister and prime minister, if this law, goes through that process, and that will remain extremely interesting to see what happens in the days and weeks ahead. But for joining me with your thoughts and your opinion on this, Manish Tewari, former union minister and a lawyer par excellence.
Thank you.
Many
Thank
thanks,
you,
sir.
Gaurav. Thank you.
So morality cannot be enforced. It's intrinsic to your system. It has to come from within. That's what Manish Tewari believes. Now let me throw it open for a wider political debate. Joining me on the show, Dr. Shama Mohammed is the national spokesperson of the Congress Party. Tuhin Sinha is the national spokesperson of the BJP. And for a legal perspective, I have Diljit Ahluwalia, a senior advocate in the Supreme Court of India. I want to begin by asking you, Tuhin Sinha, Congress leader Pawan Khera, on social media, he says Enforcement Directorate or CBI, they're like pet agencies. Through them, the government or words to that effect, they'll get the opposition leaders arrested. They will not get bailed in 30 days. And on the 31st day, they will have to resign. And they say it applies to the Prime Minister too. Tell me one minister, he asks, one minister in the past 11 years against whom the ED or the CBI have taken any action in the past 11 years, sir.
Well, good evening, Gaurav. Good evening, everybody. The Congress party, I don't know why, is so scared of facing the law. Because in 2013, when Rahul Gandhi tore apart an affidavit or maybe, a paper replicating the affidavit, he very clearly was against protection being given to Lalu Yadav. Now that, he's contesting elections in Bihar with Lalu Yadav, his stand is completely to the contrary. I heard Manish Tewari. Manish Tewari says that morality cannot be imposed. Yes, ideally in an ideal situation, and that is precisely why for the last 75 years morality was not imposed, because those who drafted our constitution never imagined a situation like this would come today. But today it needs to be imposed because for the opposition parties, depravity is the norm. Imagine, where does the need for this law come from? You would recall that last year when there was a plea to remove Arvind Kejriwal as CM when he was in jail, the High Court's observation was very clear that yes, ideally he should go, but there is no such precedent to decide whether his going is mandated by law. And therefore there was a need for such law, even in Senthil Balaji case in Tamil Nadu.
So let's take this one by one. You've raised 2 points.
Laws wherein
Sir, those instances we are playing out on television, you've raised 2 very valid points. Let me get Dr. Shama Mohammed to respond. Shama Mohammed, Amit Shah is talking about upholding constitutional morality and bringing in public trust. No chief minister, no minister or PM, he says, can function from prison. Now, it's not party specific, applies to every minister, every CM, every PM. Why oppose something that the government says or believes will bring constitutional morality in public life, ma'am?
So, Gaurav, there are a couple of things in it. Maybe Tuhin doesn't understand the law. Tuhin doesn't understand constitution, because I can understand the party he comes from. They don't understand anything. You are going to arrest a CM for 30 days. He will throw out opposition CM from states without charge sheet, without bail hearings, without a trial, without a verdict, without a judicial process. Let's understand that. So 30 days, none of these. And you know what? We don't need prosecution anymore, because the prosecution's job will be done by the investigative agency, which will be the arm of the government of the day. So can you imagine, after 40 or 60 days, this particular person has resigned, and then you find out he's been, accused of corruption, the CM or the minister. Then you find out that he is innocent. Who is going to compensate for him? Is there anybody going to compensate? Will the person who put him behind bars be punished? Will there be some sort of law for that they be punished also? So this goes against every tenet of a democracy. Basically, Amit Shah wants India to be North Korea and he's Kim Jong-un. That is what he wants, because I fail to understand how it happens. And if you look at ED cases from 2015 to 2025, around 5,994 cases, 0.1% of conviction. 173 opposition leaders, cases against them. How many conviction? 2. He spoke about the tearing by Rahul Gandhi. That is when people are convicted. One other thing I want to remind him, on morality basis, Ashwini Kumar resigned. On morality basis, our former Chief Minister of Maharashtra resigned. On morality basis, Pawan Bansal resigned. On morality basis, which minister, which CM of this party resigned? We remember, let's not forget Vyapam. I will never forget Vyapam. Maybe it's behind, but Vyapam is still there. It's a
Fair enough. For the
Shivraj
benefit,
Singh
I want
Chauhan.
to bring
He
in.
never
I want to
resigned.
bring in.
I want to
bring in
know-
Diljit Ahluwalia. We'll just take these points as many as we can. Diljit Ahluwalia, is there merit in the Union Home Minister saying opposition leaders can approach courts of law for direction? For an FIR to be filed against, ruling party ministers, should agencies not act against them? Amit Shah says there are multiple instances and examples even from the UPA era.
No, essentially this 103 bill, which has come, Constitution Amendment Bill, this
130.
is
Yes, sir.
this is the one which is directed towards the ED and CBI. Because you're not going to have a situation wherein the police of a state is going to go against a ruling minister. That is the first part. The second thing is, although the intent might be laudable, because you cannot have a chief minister running the government from the jail or even a minister doing that. I agree with that. But kindly look at it that this is violative of the basic structure of the Constitution. Article 21 has a presumption of innocence. Now here in 30 days, the presumption goes for a toss, and before his bail application also is taken up by the trial court, even if it is taken up by the trial court, he has no redress to go to the High Court and attempt to get bail from there. 31st day, he's removed. Now, this is no solace that the proviso says the moment you come out of jail, you can come back into your saddle. The question is that where is the safeguard? Look at the way it is worded, that on arrest and detention for a period of 30 consecutive days on allegations of offences which may be up to 5 years, right? He shall be removed. I mean, on the 31st day, if the Chief Minister or the Prime Minister does not give a recommendation, 32nd day, he's out. So I feel that this particular bill, whatever be the intent may be correct. I don't dispute the intent, but the way it is fanned out is violative of the basic structure of the Constitution.
Fair
this
enough.
Will not
Tuhin Sinha, respond. The fact that the opposition is raising and some legal experts are raising, take for example Arvind Kejriwal as the Aam Aadmi Party leader. He says if somebody is falsely implicated in a case, sent to jail and later acquitted, how many years of imprisonment should the minister who falsely had him implicated face?
Gaurav, these are.
Isn't this a fair question?
Gaurav,
where is
these are
accountability
presumptions
on the
similar-
part of the government or the prosecution agency?
Well, Gaurav, Caesar's wife should be above suspicion. The Congress is peddling presumptions, but fact is that similar situations have existed forever. Amit Shah ji quit the moment summons were issued against him. He was arrested on a Sunday in 2010. He quit as minister on the previous day on Saturday. LK Advani ji had, his name was merely mentioned in the Jain Hawala case diary, and he refused to contest elections till his name was completely cleared. Even Lalu Yadav quit. In the Fordor scam of in 1997, Lalu Yadav quit before he was arrested. Hemant Soren quit. So I think, it's the Congress party which wants to set a completely different precedent inspired by Arvind Kejriwal, but this depravity has no place in Indian democracy. And for that matter, I think, they should feel some shame. The Prime Minister has personally insisted that he should equally be included in the, in the ambit of this bill. Compare it with Amendment 39th Constitutional Amendment, where the Prime Minister and President were specifically kept away from judicial scrutiny. So this Congress party has no moral authority to, to lecture us, to pontificate on these issues.
Dr. Shama Mohammed, 2 points. Can a chief minister function out of jail? The rights of the chief minister, people are wanting to protect, but what about the rights of the people of this state? Will they not suffer? Can a minister function as minister from jail? Because this law is specific to chief minister, whether in state or in the center, or prime minister. Can they function from jail? And if they cannot be on 30 days, isn't it better somebody steps into that place, somebody else, and the moment they get bail, they can come back? That's the point that they're raising.
So they don't get bail, correct? One thing. And the joke of the century, not the decade, is the Prime Minister is involved in this. The Prime Minister of this country, as we know, the ED or the CBI is in his pocket. They are his puppets, as if they're going to go after him. Now, the issue here is what happened in Bhima Koregaon. We know the NIA put into the computers of Sudha Bharadwaj, of Varvara Rao, as well as Stan Swami, material which was not there in their computers, and it has been proven by outside agencies.
Outside agencies, not in courts of law in our country. So you have faith in outside agencies alleging something about what's happening in our country.
Okay, so I don't have faith in my CBI. I don't have faith in my NIA. I don't have faith in my ED. I'm being very honest.
You have faith in courts of law.
They don't have faith in judiciary also.
I didn't say court of law. I said an agency investigator. I never said court of law.
No, but let's wait for a verdict of the court of the law, because which is this agency outside? What is its background? What are their credentials? No. We do not know.
We know for sure how the BJP government, what they did in the Bhima Koregaon case. Let's all understand that. So these were falsified information put into their computers. Now, what we worry...
Says who?
It is...
Anyway, but that's not the main debate today. That's not the main debate. Let's leave that for another time.
The debate is about this government, which, as you know, not a single leader. Very important case is of Ajit Pawar. Ajit Pawar is somebody who the Prime Minister said in a speech in Madhya Pradesh he's corrupt. Devendra Fadnavis has been saying for 5 years he's corrupt. Kirit Somaiya was doing all the investigation. What happened to that particular case? Why
can I rebut this, please?
No, but you must respond, because Dr. Shama Mohammed raises a very valid point. The entire opposition is, including the Trinamool Congress, long laundry list. Anybody who joins the BJP, cases against them are dropped, sir.
No, they are just obfuscating the entire issue. See, we make political allegations, but was there any charge sheet? Was there any FIR against Ajit Pawar?
So
in fact, the Anti-Corruption Bureau of Maharashtra had exonerated him of all the charges that he was facing. Please understand, Gaurav, political allegations are different. Political allegations are different from a charge sheet or even an FIR. And the Congress is obfuscating on the issue because the Congress's sympathies lie with the corrupt, the Congress's sympathies lie with the Naxals, and that is why they are obfuscating on this issue. I have a very simple point. There is a very clear demarcation between political allegation and the process of law. A political allegation in the absence of a process of law does not qualify a person to be arrested, or for that matter
I want to bring in Diljit Ahluwalia for a legal point. A quick legal point. Permit me a quick legal point with Diljit Ahluwalia. An FIR, let's say, is registered and it's incorrect. Okay, Dr. Mohammed, you want to quickly complete your point? Let Dr. Mohammed quickly.
He said till they are corrupt, we cannot do any cases against them. There should be an investigation. Why did the Prime Minister of India, on a speech in Madhya Pradesh, say Ajit Pawar is corrupt? You're saying there has to be investigation. Prime Minister said
Point
it,
made.
Devendra
Tuhin
Fadnavis
Sinha,
said
quickly
for
before I
free,
bring in
doing
Mr.
one
Ahluwalia.
law.
Tuhin Sinha, only Tuhin Sinha now.
No, this is precisely what I'm trying to explain. This is precisely what I'm trying to explain to the Congress party. There is a difference between political allegation and the process of law. We may make a political allegation, but if there is no movement in the process of law, if there is no FIR, if the guilt has not been established, then that person is not guilty. It's as
Sir, but
simple as
that's
that.
the
Why is the
point the
Congress party
opposition is
obfuscating
making.
on the entire issue?
Sir, because that's the point the opposition makes. Anybody who joins the BJP, there is no investigation against them. It's never taken to its logical conclusion. That's the point the opposition is making. But I want to quickly come to Diljit Ahluwalia on the legal aspect here. A person is arrested, and a person has to be a minister, whether at the state or the center, chief minister / prime minister. If he or she is arrested, there are courts of law. They will decide on bail. Let's say he does not get bail from lower court, high court, division bench, Supreme Court. And right now, there's a JPC. Can our political leaders not work on bringing in systems of checks and balances and safeguards so that nobody is wrongly confined and not politically hounded through this law? And yet you have clean people and not people running governments from jail, sir.
So there are 2 points. First preliminary point is that earlier the consequences used to accrue as a result of the Representation of People Act, wherein a person, once he was convicted, these consequences used to follow. Today, these consequences are following just after the arrest. 30 days after the arrest, he loses the ministership. Or
Sir,
chief
does he
minister.
not get bail from courts is the point I was asking. There are so many levels of courts.
Yeah, so when we talk about the ED and you invoke the Prevention of Money Laundering Act, there is a reverse burden. It is for the accused to show that he is not committed the offense. So there's a reverse burden. Now, you know very well that the district judiciary, the norm even today is bail is an exception and jail is a rule. Even then, when a bail application is filed, opportunity is given to the ED or the CBI to file their reply or their counter to that. So this entire process takes at least 2 to 3 weeks for the bail petition to be heard, and for the order to come. At times it even takes 30 days. Even if, let's say, it is fast-tracked and it comes within 15 days, it goes to the High Court. High Court will again issue notice, and there'll be an opportunity to the other side to file a reply. So you don't even get the second opportunity of testing your case for bail, and you lose your seat, lose your ministership. So this is like turning presumption of innocence on its head, and I really feel that this is violative of the basic structure. This particular bill will be tested in the courts, and this will be quashed.
So, though perhaps let JPC work out systems of safeguards before it goes to a court of law ultimately. But should that happen, I'm sorry I've run out of time on this part of the show because I have breaking news and a very important story that's coming up. To all my guests, many thanks for joining me. News just coming in with more details. India has alerted Pakistan and communicated details about possible flooding downstream in the Tavi River and the Satluj River. This is information that's coming in through media in Pakistan. Though the Indus Waters Treaty remains held in abeyance after that Pahalgam terror attack, New Delhi on humanitarian grounds is reported to have alerted Islamabad through the Indian High Commission in Islamabad and not the Indus Waters Treaty Commission about possible flooding downstream. Pakistani media has acknowledged India's message alerting Pakistan to secure its people living downstream about possible heavy flooding. The second message of caution, according to media reports in Pakistan, was on rising water levels in the Satluj River. First it was the Tavi River, then it's the Satluj River, and potential release of water from dams in India. The Indus Waters Commission route was completely bypassed, according to these reports from Islamabad. Pakistan has now issued a warning to its people to evacuate to safer areas on the basis of information provided by India on humanitarian grounds. The communication has been made entirely on humanitarian grounds is the information that's coming in, and the communication was made by the Indian High Commission in Islamabad to the Pakistani Foreign Ministry on this story. I want to quickly bring in India Today's Pranay Upadhyay for more on this. Pranay, any word from the Ministry of External Affairs on this, or all information only through the Pakistani media?
Our sources in government has confirmed, Gaurav, that the communication has been made. It has been conveyed to the Pakistani relevant authorities in the Pakistani Foreign Office that we have our assessment as far as the incoming flood situation is coming, as far as the surge of the water in Satluj River and Tavi River, as you have rightly pointed it out, and that's why on the humanitarian ground, Indian High Commission in Islamabad has conveyed it to the Pakistani Foreign Office, and accordingly, the Pakistani Disaster Management Authority has issued a warning for 30th of August. We know that in Pakistan, in the recent flood in Khyber Pakhtunkhwa region, in Punjab region and various other parts of the Pakistan, around 780, more than 780 people have been died and more than 1,000 people got injured. Many people have been displaced in Pakistan and we know that India-Pakistan after May or after Operation Sindoor, this Indus Water Treaty mechanism has been put in abeyance. But on the humanitarian ground, we know that India is the leading technological powerhouse in South Asia. We have our own satellites, we have our own assessment, and you would recall, Gaurav, that India was the first country to initiate the SARC satellite concept.
Yes.
Prime Minister Narendra Modi initiated that, though Pakistan rejected that idea, but India has been helping all its neighbor in humanitarian crisis, be it Nepal earthquake or be it Sri Lanka crisis, be it Bangladesh flood. India has always extended a helping hand to its neighbor, and despite despite the acrimonious relationship, or despite the tensions, India extended this information on the basis of humanitarian grounds.
Pranay Upadhyay for joining me here on India Today. Many thanks.